Hello everyone. Welcome to the session on Personal Laws Part 3, Maintenance, Adoption and Guardianship. The objectives of this lesson are: firstly, to analyze the women's need for and the purpose of maintenance and legal provisions governing the same. Secondly, the legal rights of women in giving and taking a child in adoption. Thirdly, the need of guardianship in women's life and her rights of guardianship. Lastly, to analyze the need of secular law in the fields of maintenance, adoption and guardianship to bring about gender equality. In this session, we will discuss the position of women in law relating to maintenance, adoption and guardianship. These are part and parcel of marital life and important aspects of a woman's life impacted by family law. We shall undertake to study the various personal laws on the area and the secular law as well. Maintenance, meaning and purpose. Marriage ties the parties with mutual obligations to be fulfilled during the subsistence of marriage and at times even after the dissolution of the marriage. The prime obligation that arises out of marriage is maintenance of the spouse and children. The inferior and dependent position of women historically led to the evolution of the concept of maintenance. Law requires a woman to be provided for maintenance by her relations or family at various stages of her life as a child, wife, mother, daughter-in-law and the widow. Maintenance is the amount which she is entitled to claim from certain identified relatives in her family. It is not only a legal right but also a human right. Hindu law, Parsi law, Christian law and Muslim law provide for maintenance or alimony in India. Additionally, women can claim maintenance under the Code of Criminal Procedure 1973 and also the Protection of Women from Domestic Violence Act 2005. The law of maintenance focuses more on the husband's obligation to maintain his wife. In matrimonial laws, maintenance means the amount which the husband is under an obligation to make to a wife either during the subsistence of the marriage or upon the separation or divorce under certain circumstances. Maintenance under the personal laws. Except for the Muslim law, the other personal laws provide for two kinds of maintenance: interim maintenance and permanent maintenance. The interim maintenance is paid to meet the immediate needs of the petitioner, which covers the expenses of the proceedings as well as other expenses of the spouse during the course of the proceedings. Permanent maintenance is the maintenance that is paid after the judicial proceedings have resulted either in dissolution of the marriage or a judicial separation. Maintenance can be claimed either by the husband or the wife under the Hindu and the Parsi law. Under all other statutes, the wife is the only spouse who can claim it. While deciding the quantum of maintenance to be awarded, the court takes into account the income and status of both parties. Maintenance under Hindu law. Under Hindu law, provisions for maintenance are laid down under the Hindu Marriage Act 1955 and the Hindu Adoption and Maintenance Act 1956. Additionally, the Hindu woman also has a secular option to claim maintenance under CRPC. The Act of 1955 provides maintenance as an ancillary relief in matrimonial proceedings. A wife can claim maintenance to herself and for her children too. She also may have to provide maintenance to the husband subject to the orders of the court. On remarriage of the petitioner, the maintenance order may be rescinded. Under the Act of 1956, wife can claim maintenance while the marriage is still subsisting. Not only the wife, even a widowed daughter-in-law, as long as she does not remarry, children, unmarried daughter, widowed daughter, as long as she does not remarry, and mother are entitled to maintenance under this Act. A wife is entitled to live separately from her husband without forfeiting her right to claim maintenance on certain grounds like adultery, cruelty, etc. But her unchastity or her conversion to another religion disentitles her to this right. Thus, a Hindu woman has a right and obligation in relation to maintenance. On one hand, she is required to be maintained by her husband or parents or father-in-law or children as she progresses in her life, and on the other hand is required to maintain her children, husband and parents. Hindu Adoption Act aids the wife only during the subsistence of the marriage and does not cover post the divorce. However, the Hindu Marriage Act supports the wife only when the marriage is in a troubled state and post the divorce. A Hindu woman has three options to choose from for her maintenance, unlike other women: the Act of 1955, the Act of 1956 and CRPC. Maintenance under Muslim law. A Muslim female, that is, a wife or a child or a mother, is entitled to maintenance known as nafaka. A Muslim minor girl is to be maintained by her father before marriage. The Muslim law on maintenance is contained in Muslim Women Protection of Rights on Divorce Act 1986 and the Muslim Women Protection of Rights on Divorce Rules 1986. Prior to the Act, a divorced Muslim wife was entitled to be maintained only up to the period of iddat. But this practice was overturned in Muhammad Ahmed Khan versus Shah Banu Begum. In this case, the Supreme Court concluded that if the divorced wife is able to maintain herself, the husband's liability ceases with the expiration of the period of iddat. But if she is unable to maintain herself after the period of iddat, she is entitled to have recourse to Section 125 of the Code of Criminal Procedure. This decision led to a controversy as to the obligation of the Muslim husband to pay maintenance to the divorced wife. To undo the effect of this case, the Muslim Women Protection of Rights on Divorce Act 1986 was passed, which provides that a Muslim divorced woman shall be entitled for a reasonable and fair provision and maintenance within the period of iddat by her former husband, and in case she maintains the children born to her, such maintenance would be extended to a certain further limited periods. But if she is unable to maintain herself after iddat, the magistrate may make an order for the payment of maintenance by her relatives or by the Waqf board if she has no relatives. However, the Supreme Court has held that provision for post-divorce maintenance shall be made by the husband before the iddat is completed, else she can claim maintenance even post-iddat. The same principles applicable under Section 125 also govern a petition under the 1986 Act. She is also entitled to unpaid dower and all such properties which were given to her during her marriage by her husband or relatives. The Act also gives an option to the husband and wife to settle the matter under Section 125 to 128 of CRPC and not under Section 5 of the Act of 1986. It is pertinent to note that the Apex Court has held in Daniel Latifi versus Union of India that a Muslim husband is liable to make reasonable and fair provision for the future of the divorced wife, which obviously includes her maintenance as well. Such a reasonable and fair provision extending beyond the iddat period must be made by the husband within the iddat period in terms of Section 3, subsection 1, clause A of the Act. Liability of the Muslim husband to his divorced wife arising under Section 3, subsection 1, clause A of the Act to pay maintenance is not confined to iddat period. Her right to maintenance during marriage remains unprejudiced even she has property or income of her own and the husband is poor. A husband is bound to maintain his wife though a non-Muslim. In addition to this maintenance, she may also be paid certain special allowances like Karch-e-Pandan, Guzara, Meva Khori, etc. However, the Muslim wife's right of maintenance, that is absolute during the subsistence of marriage, ceases on the death of her husband. That is, the widow is not entitled to maintenance during the iddat of death. Maintenance under other laws. Maintenance is well provided under the other personal laws like the Parsis, Christians and the Special Marriage Act 1954. The provisions are same under the Parsi, Christian laws and the Act of 1954, and the same considerations are applied in granting maintenance that are quite similar to the Hindu Marriage Act 1955. The Christian and Parsi woman can claim maintenance from her spouse through criminal or civil proceedings. Maintenance under Code of Criminal Procedure 1973. Section 125 of CRPC deals with maintenance of all divorced or neglected wives, abandoned children and aged parents of any religion. This right is available only against the husband or father or son. A minor girl who is married may be entitled to claim maintenance from her husband or father subject to certain conditions. On an application being made to the magistrate, maintenance is granted to the affected party according to her needs. If the wife is found entitled to grant of maintenance within the parameters of Section 125 CRPC, such maintenance should be adequate so that she can live with dignity as she would have lived in her matrimonial home. Fine or imprisonment may be ordered to compel the payment of maintenance amount. However, the wife is not granted with this right if she commits adultery or refuses to stay with the husband without any sufficient reasons or they are living separately by mutual consent. Thus, we see that a wife's right to receive maintenance under Section 125 CRPC, unless disqualified, is an absolute right. Maintenance under the Protection of Women from Domestic Violence Act 2005. This is an additional protective measure to women on secular lines. Under the Act, the magistrate can direct the respondent to pay monetary relief to meet expenses and losses of the aggrieved person and children of the aggrieved person. We will now look at adoption. Adoption is a beautiful alternative for childless couples and homeless children as well. Through adoption, people take a child not born to them and raise it as a member of their family. Even though adoption is an age-old practice among Hindus, adoption law was codified only few decades ago in India. The other personal laws do not recognize the institution of adoption except where customs permit such adoption for a section of their followers. Since adoption forms the subject matter of personal laws, we do not have a uniform law, thus resulting in 3 laws that operate in the area of adoption: Hindu Adoptions and Maintenance Act 1956, the Guardians and Wards Act 1890, and the Juvenile Justice, Care and Protection of Child Act 2000. Central Adoption Resource Authority is the apex controlling body in matter relating to adoption in India under the Ministry of Women and Child Development for legal adoption of Indian children. Muslims, Christians and Parsis and Jews are governed by the Act of 1890 as formal adoption is not recognized in these religions. adoption among Hindus is governed by the Act of 1956. The Act of 1956 has brought about some institutional changes in adoption. Under the old Hindu law, only a son could be adopted and only a male had a right to adopt without the consent of the wife. Such gender biases have been minimized by the Act of 1956 and further minimized by the recent amendment made to Section 8 in 2010. Currently, every Hindu female who is a major and is of a sound mind can take a son or a daughter in adoption to herself in her own right, either she is unmarried or is a widow or is a divorcee. If she is married, she can adopt with the consent of the husband. A father or mother shall have equal right to give the child in adoption, but with the consent of the other spouse. There should be an age difference of 21 years between the adoptive parents and the adopted child whenever they are of opposite gender. Non-Hindus desirous of adopting a child can only take the child in guardianship under the Guardians and Wards Act 1890. Unlike the adopted child under the Act of 1956, the child cannot inherit the guardian's property by right. This act confers only a guardian-ward relationship. The process makes the child a ward, not an adopted child. Thus, we see that while a Hindu woman is granted a right of taking in or giving in a child in adoption, women of other religions are not blessed with this right. Until a secular code is adopted, the women following other religions will not be allowed to adopt like the Hindu women. The National Commission for Women has stressed on the need for a uniform adoption law. These two acts did not address orphan and abandoned children. However, adoption of such children is specifically dealt under the Juvenile Justice Care and Protection of Children Act 2000. This enactment provides a secular approach to the concept of adoption. It allows adoption of children by an individual of any religious community. After the amendment in 2006, the status of the adopted child was made equal to that of a biological child. Under this enactment, any woman, irrespective of her marital status, can adopt a child. It is pertinent to note that non-Hindus desirous of adopting a child other than an orphan or abandoned child still do not have an avenue to legally adopt a child. Several attempts were made in 1972 and 1980 to bring a secular adoption law in consonance with the provisions of the Constitution and international commitments. The Adoption of Children Bill failed due to objections from various religious groups. The religion-specific institution of adoption requires a secular touch to fulfill the constitutional mandate under Article 44. We will now look at guardianship. A guardian is a person who has the duty of care and protection of person and property of a minor who is called a ward. The need for guardianship arises due to infancy or incapacity or disability of the ward. Usually, the parents of a minor child are the legal guardians of that child, and the parents can designate the child's legal guardian on their death. In the absence of a uniform law, Hindu Minority and Guardianship Act 1956, Muslim Personal Law, and the Guardians and Wards Act 1890 are the three distinct legal systems that govern the question of guardianship of a minor child. The courts have repeatedly held that child's interest is paramount in issues of guardianship, even by overruling or watering down statutory provisions. Due to this progressive outlook, the position of women is seeing a change for the better in recent times. After the Personal Laws Amendment Act 2010, the Act of 1890 allows the mother along with the father to be appointed as a guardian, making the process gender neutral. The Act provides for the mother to be appointed as a guardian along with the father so that the courts do not appoint anyone else in case the father dies. Guardianship under Hindu law. Guardianship was unknown to ancient Hindu law. The courts developed the institution of guardianship in India during the British regime. The law relating to guardianship was first codified in the Guardians and Wards Act 1890. This act is applicable to Muslims, Christians, Parsis and Hindus as well. The Hindus are also governed by the Hindu Minority and Guardianship Act 1956. The Act of 1956 is not a substitution but an extension of the Act of 1890 for the procedure as well as the substantive law in regard to the rights and duties of guardians. The mother is the natural guardian of her minor legitimate children only if the father is dead or otherwise incapable of acting as guardian. But where the child is less than 5 years, the custody falls within the mother. The mother is the natural guardian of the minor illegitimate children even if the father is alive. If the mother survives the father, she would be the natural guardian of the child and not the testamentary guardian. Further, the mother too can appoint a testamentary guardian of her own choice when she survives her husband. Where minor female is married, guardianship rests on the husband. Mother's right of guardianship is not lost on her conversion to another religion so long as she is able to provide a congenial, comfortable and happy home. The position of mother's guardianship of her adopted children is the same as that of her natural born children. However, in Geeta Hariharan versus Reserve Bank of India and Vandana Shiva versus Jayanta Bandyopadhyaya, the Supreme Court has held that under certain circumstances, even when the father is alive, mother can act as a natural guardian. Guardianship under Muslim law. In Muslim law, the father while alive is the sole guardian. Father's right extends both to person and property. Whether it is legitimate or illegitimate children, mother can never be a natural guardian. She has only custody rights over the child up to a certain age of the child. Misconduct is the only condition which can deprive the mother of this right. Mother is not recognized as a guardian even after the death of the father. Though mother may not be a natural guardian, she may be appointed by the father as a testamentary guardian. She can appoint a testamentary guardian only when authorized or with respect to her own property that devolves after her death on her children. On the failure of the natural guardians and testamentary guardians, the Qazi appoints the guardian. Now, the appointment of the guardian is governed by the Courts and Wards Act 1890. Thus, we see that the secular law governs them only in the absence of the natural or testamentary guardians. It is time Muslim women's rights on guardianship are revisited. Guardianship under other personal laws. Among Christians and Parsis, though there is no general law of guardianship and adoption, they are governed by the Act of 1890. They do not have adoption laws and can take a child only under foster care following the process laid down under the Act of 1890. The matters relating to guardianship of minors in respect of their person and property are governed by the said Act. Let us now conclude with a few words. The patriarchal society shaped a woman to be a dependent individual. It is this dependency which led to the evolution of the institution of maintenance and guardianship in a woman's life. As can be noticed, there is a wide divergence based on the religion she belongs to. It appears that non-Muslim women's position is better in the areas of maintenance, adoption and guardianship, while women of other religions are protected by their personal law and the secular law as well. Muslim women are denied parity. It is time for a serious introspection and debate on these fundamental aspects of every woman's life. Hope you enjoyed this session. Thank you.